us in this room are very lucky and have a tremendous chus that on this special day of Teves, a day that was declared by the Rebbe as a Yom Tov for every chassid and for every yid around the world, that of all of the, I can only imagine the untold number of invitations that Mr. Lewin received on this special day, and every day, but especially today, that he so graciously accepted our invitation. So first of all, let's give him a hakaras hatov.
Rabbi Kunin, for your very generous introduction. And I have to explain that each year at this time on Hey Teves, we may be in different places in the world. The most difficult Hey Teves I've ever had has been when we were in Eretz Yisrael for Hey Teves, and with all the Chabad locations around Eretz Yisrael, I was picked up and transported all day from one location to another to be asked and honored to speak at those locations. This year, we happened to be in California, in Los Angeles, and Rabbi Kunin very generously invited me to speak to you. And I thought that since we are here in California, it would be an appropriate simcha, really a local simcha, for me to be able to talk to you and celebrate Hey Teves that way. Rabbi Kunin mentioned the Rabbitson Allahu Shalom. So let me begin with that, really, because that may be of great interest to you. I don't know whether you know the background of the dispute that led to the great celebration of Hey Teves, but it was a disagreement over the library of the Frierdiker Rebbe, of the sixth Lubavitcher Rebbe, and the library that was brought to the United States after the war, and the family of the Frierdiker Rebbe, of the sixth Rebbe, was in disagreement over who the library belonged to. One of the daughters of the Rebbe said it was a family possession, and her son, Barry Gurari, who was the only grandchild of the fifth Rebbe, really, and he was not active in Chabad, and he claimed that it was a private possession. And therefore, the issue before a court in the United States was the library a private possession of the Schneerson family, or did it belong to Agudas Hasidei Chabad? And a key witness in all this was the younger of two sisters, who was the Rabbitson. I hope that the transmission is working. Yes, so I'll keep speaking to you, yes. But I no longer see you.
Yes, we hear you. That you're perfect. Yeah.
So, how was the testimony of the Rabbitson Allahu Shalom taken? Well, the legal process provides that witnesses can be subjected to what's called a deposition, in which the lawyers are present and the stenographer takes down the testimony, which is, for all practical purposes, under American law, sworn testimony, even though, of course, from Jews don't swear, but nonetheless, they affirm that they will tell the truth. So I had the great privilege of being in the home of the Rebbe and the Rabbitson, where the deposition was taken of the Rabbitson. And as careful lawyers, I and other members of my team advised her in advance that when questions were being asked by the other side, by the lawyers on the other side, she should insist that the question be translated into Yiddish, because that would give her time to think about the answer and to provide an answer in Yiddish, which would then have to be translated for the record into English. Well, the Rabbitson was a very wise woman. She knew Yiddish, she knew English. I don't know how many other languages were really just very natural to her. But she took the lawyer's advice at the beginning of this deposition. I was sitting there in the room, and there was a court reporter, and the lawyer for the other side asked questions. I'm getting an echo, asked questions in English. And as we had instructed, the Rabbitson first said, translated into Yiddish. Well, that went on for about 3 or 4 questions. And then she just decided there was no need to listen to our very tactical suggestions. And when the questions were asked in English, she answered them in English without going through this process of saying, please translate it into Yiddish so I can answer in Yiddish. And she answered all the questions perfectly. I mean, exactly as we had wanted. We sat there and listened, and the record was being taken. And then the lawyer for the other side asked what he thought was going to be the final series of absolutely strong questions. The issue was whether the library was a personal possession of her father. And he said, so tell me, didn't your father have personal possessions? What did he own? And of course, our testimony in the court was that in Chabad, the object was not to make the Rebbe rich or not to treat the Rebbe as being personally rich, but that the Rebbe was serving for the community, for the Chabad Hasidim. And she said, in response to the question, he had very little personal. And then the lawyer said, well, now tell me, what did the Rebbe own personally? He. And she replied in what is a classic response that has gone down in the history of the Teves litigation. She replied, my father, the Rebbe, belonged to the Hasidim. He didn't have any personal possessions. He was owned by the Hasidim. That was very dramatic. So dramatic, and I have to tell you that as a lawyer, I didn't rehearse that answer for her. I didn't tell her, say to the question that the Rebbe is owned by the Hasidim. But she said it on her own. And it was so compelling that when the time came for the actual trial before the judge, although she did not have to testify in person, we actually played the recording of that testimony to Judge Sifton. And it was very, very compelling and very strong. The whole case was, I need not tell you, the highlight of my now 60 years in the legal profession, because it gave me the opportunity not only to deal with questions of halacha, Jewish law, but also with so many important issues affecting the Jewish community and affecting Chabad. From the very beginning, it was a very, my personal experience, it was a very dramatic opening. I was sleeping 2 o'clock in the morning, and the phone rang. I picked up the phone, got awoken by the ring, and who was on the other side but Rabbi Yehuda Krinsky, a mayor of Yesrin, a such important leading figure, not only leading figure then and now in Chabad, but also very close associate and a person who accompanied the Rebbe wherever he went. And Rabbi Krinsky says to me in the middle of the night, Mr. Lewin, he knew I was a lawyer. I had done some representation of Chabad before. What do we do if somebody has stolen books from the library, from a Chabad library at 770 Eastern Parkway? Can we go to court? Should we report him to the police? And I arranged with him that he would come, or somebody from Chabad would come to my office to discuss this as to whether we could take the case to court. They showed up in my office, not just with the details of the case, but also with a page from the Choshen Mishpat, from the Shulchan Aruch section on dealings, business dealings between partners and others. And the Choshen Mishpat, of course, tells you that if you have a disagreement with another Jewish person, it should be resolved in a Bezdin. You should not go to a secular court, to what the Gemara calls arkos. So the opening question was, since this was a disagreement and books had been taken by Barry Gurari from the library, could we go to an American court to make him give those books back? We knew that the books had been taken very surreptitiously and were being sold as antiques to collectors for substantial prices. How could we stop him from doing that? Could we go to an American court? And at the very first meeting that they had with me, the representatives of Chabad said clearly at the instruction of the Rebbe that I have to be satisfied, I have to be told and advised by them why Chabad can go to a secular court to get these books back. And so I was brought at the very first meeting a page of the Choshen Mishpat, which had written on it on the side by a posek, leading posek from Chabad, on the side of the margin, which talks about not going to Arkos when you could go to Arkos if the other side was not going to listen to what a Bezdin would say. And in this case, it was clear that Barry Gurari was not going to give the books back just because a Bezdin would tell him to give them back. But the Rebbe was very careful to make sure that there was no halachic question about going to a court. And so we went to court. We filed a case in court, in federal court, and to get the books back. And I will tell you that although the case has become famous and the judge who issued the decision on Hey Teves in favor of Chabad is Judge Sefton, who was not Jewish, when we filed the case and we wanted to be sure that the books would be safe, Judge Sefton, who was assigned the case by a go roll, by a lottery in the clerk's office, was on vacation. So instead, the case that day went to a Jewish judge in the federal court, whose name I just momentarily forget, but a Jewish judge in the federal court in Brooklyn. And I recall that we walked into his office, I and the lawyer on the other side, whose name is Alvin Hellerstein, walked into the office of this judge, not knowing whether he would issue an order that would say that the books have to be kept during the time that we have this trial. And I walked into his office and felt very good, because suddenly I saw right on the lobby, on the outside of his personal office, in a very ornate frame, was a daf, a first page from a Rambam printed in the 18th century, which he had framed and put in his office. So that made me feel we probably were going to be before a sympathetic judge. We had siyata d'shmaya. We went to the judge, and the judge ordered that the books that Barry Gurari had taken should be kept until the conclusion of the trial, which was going to be before Judge Sifton. We had, in addition to Rabbi Krinsky, of course, other important people at Chabad who were very much involved in the discussions regarding the case. Rabbi Avram Shem Tov was there, and others. And in the case itself, we had lawyers who were really outstanding lawyers who helped me. One was Jerome Shestak, who later became president of the American Bar Association. Another one was my partner, my then young partner, Seth Waxman, who years later became Solicitor General of the United States in the Clinton administration, and has gone on to great legal renown for the work that he has done. So we had the trial. I'm not going to spend a lot of time today talking to you about the details of this trial. I can only tell you a couple of very interesting sidelights and anecdotes about the trial. It was the best attended trial I have ever had. I've represented a lot of very important people in trials. And very often the spectator seats at the back of the courtroom have been full or almost full. In this trial, every seat was taken for every session, fully. The first three rows on one side, you'd be interested to hear, were all set aside for women. The rest of, on the other side, sat men. At some point, when they saw that the trial was going very badly for them, the other side complained to Judge Sifton and said, "This is not American. Look, Judge, look at the courtroom. Every day there's separate seating by gender. Women are sitting on one side in a few rows, and then the other rows have got only men. This is not American. Can't allow this." And Judge Sifton said to them, and this was at a conference at the bench, which I think is part of the court record, "I have been sitting here every day marveling at how attentive the entire audience is to what is going on, the men and the women. I have not seen anybody wanting to sit at a place other than where they have voluntarily been sitting. This is a totally voluntary separation by gender, and I don't want to hear any more from you about this." He really got angry at the lawyer for the other side about having raised this question of separate seating in the courtroom. We had, of course, terrific witnesses. One of the most famous witnesses we had on our side was the very celebrated Eli Wiesel, Zechron Livracha, who was, even then, so many years ago, a leading spokesman for peace, for recollection of the Holocaust, of the terrible things that had been done to our people during the Shoah. And Elie Wiesel testified as an expert on Hasidus and on Chabad. We had other witnesses from Chabad itself, of Zalman Posner, Zichrono Livracha of Nashville, who was a master of English writing and very articulate, and was able to speak to the issues that were presented by the case. We had even Rabbi Louis Jacobs, who was a controversial figure in England because he'd written some historical material that caused controversy and prevented him from becoming the dean of Jews College in the United Kingdom. But he volunteered to be an expert and was an expert witness on our side. An interesting anecdote about the case that you might want to find funny is that Judge Sifton's courtroom was immediately adjacent to the courtroom of another judge, federal judge in Brooklyn, who was frankly not a hard worker. He took a lot of vacations. He spent as little time as possible in his courtroom. And soon after the trial began, we noticed, and the Chabad folks who came down in yellow buses every day to the trial noticed that that courtroom was empty for pretty much most of the day. So after, I think by the second or third day of our trial, the Chabad group came down with sandwiches and everything for lunch. And when the lunch break came in the trial, we would go next door to this empty courtroom. And this empty courtroom in the US courthouse in Brooklyn was turned into a location where at lunchtime, we would daven mincha and have lunch, a kosher lunch brought from Crown Heights for all the people who were sitting on that trial. So the trial went on, and it was very dramatic. It ended. Judge Sifton had a major criminal case after the trial that we had. And there was a period of time before he could issue a decision. And then finally came the day of Hey Teves. It turned out to be Hey Teves when he issued the decision in which he said that the library of the Frierdiker Rebbe belonged to Agudas Hasidei Chabad and not to Barry Gurari and his family, but it was a possession of the whole Chabad community, and the Chabad community owned it. And the Rebbe, who had gone to the OL, I hadn't even known. I was a lawyer. I was in Washington. I didn't know till after the trial ended how much this case meant to the Rebbe. We had 2 sessions, Yechidus with the Rebbe, to talk about the case. And the Rebbe had pointed to the letter that was the key document that on which Judge Sifton relied on. But from the very beginning, he said, that's the most important indication that this library belonged to Agudas Hasidei Chabad. But I didn't know that every day during this trial, the Rebbe went out to the Ohel, drove out to the Ohel in order to say tefillos so that we would prevail. And b'siyata d'shmaya, his tefillos, of course, were answered. Judge Sifton issued his decision, and it was a decision that although the other side tried to take an appeal, the appeal, after some time, was decided in our favor, and that conclusively established that that library belonged to Agudas Hasidei Chabad. And as Rabbi Kuhn has mentioned, because of the efforts of him and his father, Admei of Yesrim, and his brother, a strong delegates who the Rebbe appointed to see to it that the library of the fifth Lubavitcher Rebbe, the Rebbe before the Frierdiker Rebbe, who had had a library that the Soviet government, the communist government, had taken and not returned to Lubavitch, that library should be brought to the United States and put in to Crown Heights together with the library of the sixth Rebbe, which we won. And that litigation, again, I had discussed that at the request of the Rabbi Kunin, of Meir Vesrim and his sons, and others at Chabad, I represented Chabad in that litigation as well in Washington, D.C., and we won an overwhelming victory. The court said that we won and that Russia had to return that library. And because they have not returned it, they now owe millions of dollars to Chabad as punishment. We have to try to collect that. So that's a couple of my recollections about the events of Hey Teves that led to Hey Teves. And I'd be glad if there's time and if you're interested to answer any questions that you may have about it.
Hi, I'm Myers from Los Angeles, California. Now come over here so you can be in the camera.
You can face me.
What are you doing to reflect on the judgment of getting the sperm from Russia?
Can you just repeat that question so I can hear it clearly?
What are you doing to collect on the judgment to get the sperm from Russia?
We have, and we've gotten a law firm called Rothwell Fig with a very impressive lawyer called Steve Lieberman, who is trying to find assets that belong to Russia in the United States, to threaten to be able to collect those for millions of dollars under court order. The court has ordered that those sfarim be brought to the United States, be sent to the United States. I requested, and the court granted, that there would be a penalty of $50,000 a day for Russia not agreeing or not doing it. That amount has continued to increase day by day. But the problem is, in an American court, in order to enforce that judgment, you have to find property of the foreign government against which you can collect that amount of money. That's very limited. So we now have a leading law firm that's an expert in going after and finding funds for judgments. And they have been trying to get assets of Russia that we could reach so as to get Russia and Mr. Putin, who personally has been involved in this. I have to tell you, it's not necessarily a matter of great public knowledge, but I will tell you, because it's not a secret, that we were very close to getting the books brought to the United States until Mr. Putin personally overruled that and said, no, he wants to keep that library in Moscow. So that library is in Moscow right now, even though it's under a US court order to have it returned to the United States, because Mr. Putin himself has said he wants to keep the library in Moscow.
Wow, thank you so
That's
much.
what we're doing.
Three questions. Come close, so then.
How do we ensure that Russia pays the $50,000 a day that America is meant to gain? I mean, Chabad.
How do we assure that?
Yeah.
Well, we have to, that's the problem. We have to find the money. So right now, there was a decision on Hanukkah by a court of appeals in Washington, D.C. on the question of whether a company that had records that might lead us to money belonging to Russia could refuse to comply with a request to produce their records. The Court of Appeals said, sorry, can't do that. We have decided years ago, in the case in which I brought to the Court of Appeals, again, at Rabbi Kunin's urging, that the court had held that Russia was responsible and had to return the books as well as other documents. And then Russia got so upset by the fact that they had lost the case in the American courts that, to use a childish analogy, they took their marbles and went home. They said, no, we're not going to play anymore. We're leaving. You can't do anything to us. So that's the position that we're in right now with regard to that case.
Thank you. Okay, and our last question from Ken. Close the camera so that.
Was there any doubt or fear that you wouldn't win the case?
Again, I'm not, the voice transmission is not so good. I need to hear that more clearly.
Was there any doubt or fear that the Hasidim wouldn't win the case? And they wouldn't get started?
Was there any doubt or fear that the Hasidim in the story of Teves wouldn't win the case and wouldn't get the start? Is what she's asking.
Was there any doubt about Hasidim in the Soviet Union?
In the original Teves story, was there a doubt and a fear that maybe we're not going to get this firm?
Well, I assume, again, of course, like any litigation in our codes, in non-Jewish courts, you don't know whether you're going to get a fair judgment. And one of the things I was thinking about, and it's appropriate really for this time of the year, after Teves. I mean, what do we have this week, Sedra? This week's Sedra is Vayigash. And what does Vayigash tell us? Vayigash tells us that when Yosef told Paro that, his father would come, what does the pasuk say? The pasuk says that Paro was happy and invited. What? Vayitav ve'enei Paro ve'enei avodav. That Paro was happy and welcomed the Jews and welcomed the fact that Yaakov and his sons were going to come to Mitzrayim. But you have to be careful. Paro may have done that, but, and my grandfather, the Reish Rav, said very cleverly, we say every Pesach, we quote from the pasuk, "Vayoreu osanu hamitzrim," "Vayoreu osanu hamitzrim." I'm sure you're learning, when you're learning Hebrew and you're learning Chumash, Vayoreu can have two meanings. It can mean Ra, they did bad to us, or Vayoreu, they acted like a Reya. Reya, v'hafta l'reya hakamocha. That's what the Egyptians did. That's what Paro did. Paro was first a Reya. Vayoreu osanu hamitzrim. They said, we love you. But then Vayoreu, no, they did evil to Bnei Yisrael. And we had to suffer Avdus for 210 years until we could get out of Mitzrayim with Moshe and HaKadosh Baruch Hu leading Bnei Yisrael out of Mitzrayim. So there was uncertainty. Every time you deal with an outside community, there's uncertainty. Of course, we don't know. You look at the United States today, who knows? people are saying there's greater danger of anti-Semitism in the United States. We know there's more anti-Semitism. When I grew up in America, it was, in the Yiddish phrase, a golden Medina. I came to America when I was 5 years old. Didn't know any English at the age of 5 years, but I learned English. And again, with Ezra HaKadosh Baruch Hu, I managed to succeed. I became a lawyer. I clerked on the Supreme Court. I had all kinds of opportunities. But today the world is different. So we have to watch it.
Take a sip.
Well, because today is such a special Yom Tov, and we have the power of all these daughters of the Rabbitson, because we know that the Rabbitson said, my children are in 770, and we're all here together in the Rebbe's house in 770. We have the power. We would like to all give a bracha to the Steve lawyer, Mr. Lewin, together. Barichas Yamim v'Shanam Teves, and you should have tremendous hatzlacha in your incredible shluchos of redeeming the captives, the Rebbe's Sfarim, which you know the Rebbe told my father, there's a Sfarim and Sfarim to Mashiach. We're going to travel together with the Sfarim to Mashiach. So together with them coming out, we can see it's happening. This is what we told us. They're being 2 a day, and we're finding treasures here in America that cost that much, so we can hold on and say, we're keeping this. So they're really being forced B'derech HaTeva and L'mayla min HaTeva to bring that, and what's happening with Mashiach. So everything that we davened for, we said this morning, you can ask for anything. That's all happening right here today. So we have the power of giving a bracha, and the Rebbe said the best, most efficient bracha that I did, that Hashem wrote in the Torah, that we say every morning we bracha. So let's all say that, and we're going to say it together. Vayidaber Adonai Alay Shalemer Daber Al Aaron Alban Lemer Kaisa Baruchu Esmei Yisrael Amar Lahem Yivarechecha Adonai V'Yishmerecha Ya'er Adonai Pana V'Lecha V'Chunecha
Amen.
Adonai Pana V'Lecha V'Yasem V'Chad Shalom.
Amen.
Thank you so much.
Thank you.
Thank you.
Good.